Selling your home, either with a real estate agent or by yourself, is an exciting but hectic process. Among the legal considerations is the requirement for disclosing the condition of the property to potential buyers. The seller of property, especially residential property, completes disclosures about any and all known problems with the property in an attempt to avoid issues with the buyer later claiming no knowledge or concealment of defects with the property. Today we will go over the basics of a property disclosure as well as a federal disclosure requirement imposed on older homes. First, let's go over the property condition disclosure. The form is completed by the current owner of the property or authorized seller. It basically outlines the flaws that the seller knows about that could negatively impact the property value. On this disclosure, you will reveal things like the age of the home, the age of the roof, the age of the heating and cooling systems, the age of the appliances, any issues with the foundation, any flooding or drainage issues, repairs made by the seller during ownership, including improvements and insurance claims, the instance of any mold or pest infestations, disclosure of repairs or changes to the property done without a permit, issues with any doors or windows not opening. Some disclosures also provide information to the buyers regarding annual taxes, HOA dues, utility providers, and average yearly utility costs. When do you provide this disclosure? In most instances, the disclosure is done at the time the property is put up for sale. The seller makes it available to potential buyers before they place an offer. But in some places, the disclosure can be provided after the offer has been accepted. Buyers want time to do their due diligence and identify problems that might change their mind about purchasing. The law typically gives them this opportunity. Even if you wanted to sell your property as is, a disclosure would still be required. Remember, sellers only need to disclose issues that are known to them. They are not required to research for issues. That is why buyers are recommended to get their own inspection to look for potential problems not known. Is your property older? Was it built before 1978? If so, then you'll have another disclosure to include when you sell the property. Federal law, specifically the Lead Paint Hazard Reduction Act of 1992, requires the owner to, and these requirements must be completed for your sales contract to be enforced. So they're required to deliver to buyers a fully completed disclosure statement regarding any lead-based paint or related hazards in the house. The buyer also initials and signs the form. Required to give the buyers the approved EPA pamphlet called Protect Your Family from Lead in Your Home. This pamphlet explains the potential problems in these older homes and how to combat the hazards. You allow your buyers 10 days to test the house for lead. You include warnings in your sales contract. And you keep the signed acknowledgments for 3 years as proof you followed the law. So remember, as a seller, if you disclose everything you know about a house to your buyer, you are protected from someone saying they didn't know. If you are a buyer, the disclosures provide you with vital information about the home so you can be an educated buyer. Having the information up front can make for a smooth transaction. Everyone will be happier with full disclosure. Thanks for joining me.